Today's presentation is titled, Why is my company being sued in Madison County, Illinois? I'm Courtney Stevens, an attorney in Medmarc's Loss Control Department. On behalf of Medmarc and today's presenters, Mark Crane and Jordan Litz of our defense panel, thank you for joining us. Jordan Litz, a partner at Davis Graham & Stubbs, LLP, is a litigator who has enjoyed wide-ranging success, both in the courtroom and through motion practice. He wrote the book on product liability law in Colorado, literally, Product Liability Law and Procedure in Colorado. And he is an adjunct law professor at University of Denver's Sturm College of Law, where he teaches outdoor recreation and ski law. Mr. Litz has received numerous recognitions for his work, including being previously named by the Colorado Civil Justice League, Colorado's Tort Reform Coalition, as the Colorado Lawyer of the Year. Jordan is one of the leading product liability defense attorneys in the Rocky Mountain region. He has had broad experience defending product manufacturers in lawsuits in Colorado and throughout the nation. He represents virtually all types of companies regulated by the FDA, including pharmaceutical, medical device, dietary supplement, and food companies. He also represents various manufacturers, including car, truck, machinery, farming, and consumer products manufacturers. He has defended hundreds of individual personal injury actions as well as coordinating mass tort actions, and his experience ranges from such areas as traumatic brain injury litigation to asbestos claims. He is active in the product liability world, including serving on the Law 360 Product Liability Editorial Advisory Board. Whether at the summary judgment stage, through Daubert motions, or at trial, Mr. Litz knows how to succeed in product liability cases. He also understands that his client's reputation and the integrity of their product are their most valuable assets, and works vigorously to defend that reputation and integrity. Mark Crane has over 30 years of experience handling all aspects of civil litigation, with a particular emphasis on the defense of complex product liability matters and mass tort litigation. He joined Siegel McCambridge in 1989 and currently serves as the firm's managing shareholder. In today's litigious world, many businesses learn the hard way that litigation can destroy a company's reputation, drain its financial lifeblood, and, particularly in the case of mass tort litigation, lead to catastrophic losses and even bankruptcy. Whether you face a single lawsuit or bet the company mass tort litigation, it's crucial to choose the right defense attorney. For nearly 30 years, clients ranging from industry-leading multinational corporations to smaller family-owned businesses have relied on Mark Crane to protect their reputation and bottom line in tort litigation, not only because of his experience, knowledge, and record of successful results, but because he takes the time to learn and understand their business in order to provide the most effective and cost-efficient defense possible. This client-centric approach enables Mr. Crane to successfully defend individual lawsuits and find solutions to the larger or complex challenges presented by recurrent or mass tort litigation. Mark has served as National Coordinating Counsel for several major corporations, working closely with his clients to develop strategies for effectively evaluating, defending, and successfully resolving cases through the country while effectively controlling the cost and risk of litigation. He provides candid advice to help clients make the right decisions in responding to litigation, whether that means aggressively contesting a case at trial or reaching a reasonable settlement to avoid unproductive litigation costs. With that, I am pleased to turn things over to our first speaker, Jordan, who will begin today's presentation.
Good afternoon, everyone. So I was at a client conference where they sort of gathered their tort defense counsel from throughout the nation, all in one location, so we could meet, discuss strategy, things of that nature. And one of the first things that struck me at this meeting was there were two attorneys from the Rocky Mountain West. There was one attorney from Salt Lake City, and there was me from Denver. And then at the same group of attorneys for the same client of mass tort litigation, there were 5 attorneys from Madison County, Illinois. Now, to put this in perspective, there are 25 million people who live in the Rocky Mountain West, and there are roughly 269,000 people who live in Madison County, Illinois. And, you know, this concentration of attorneys is really indicative of where companies get sued in tort litigation. And that's what Mark and my presentation today is about, is what causes this need for 5 attorneys in what would otherwise be considered one random county in the entire United States. In fact, the title of this presentation, as Mark and I were trying to come up with it, Why is My Company Being Sued in Madison County, Illinois, is actually a direct quote that I heard from a particular client of mine. I've heard that exact same quote as to Alameda County, California, Los Angeles County, California, and plenty of other locations, certainly for device, drug, and other manufacturing companies that aren't sued on a regular basis. It's a bit odd to get pulled into these jurisdictions. So our presentation today is going to be about these jurisdictions, and just a brief overview of what we're going to be talking about over the next hour. We're going to start by talking about what are these bad jurisdictions, why do they occur, where are they, and how are they each different from each other. So that's sort of the first piece. The second piece is that we're going to talk about the proactive steps a company can take to avoid being sued in locations such as this. And quick spoiler alert, everyone, there aren't many. So there's not much that we can do to avoid getting sued in these locations, but there are some things depending on our companies. And so we'll talk about that next. Third, we're going to talk about the various strategies to get out of these courts once your company is sued in them. And there are several strategies to try to get out of these courts. And then finally, we're going to talk about how to make the best of it if you are actually stuck litigating in one of these bad jurisdictions for corporate defendants. So that's sort of how our talk is going to go through today. And I figured that we would start by first talking about what makes these plaintiff-friendly jurisdictions, these jurisdictions that are particularly bad for drug, device, and other manufacturing clients. And there are really four factors in that. The first one, and this is all fairly obvious, is the jury pool. As we all know, there are certain jurors out there who, no matter what, will always side against the big corporation or the out-of-state corporation. And there are also jurors out there who are happy to give outrageously large awards. Those are two different things. Jurors can differ between those two, but when you get a combination of those two, when you get a concentration in the jury pool of people who either have corporate animosity and or like to award big dollar numbers, that's when you have the jury pool that creates these problem jurisdictions for various companies. Second part, obviously, is a concentration of plaintiffs' counsel. Just initial thing, if everyone thinks about it. Lawyers, like anyone else, are lazy and they don't like to travel. And this is true whether it's plaintiffs' attorneys or defense attorneys. They just don't like to travel. And so what naturally happens is people take jobs where there are a lot of jobs, and they tend to like to file lawsuits and, to a certain extent, defend lawsuits in their home locations. So what happens is simply there's a concentration in the product liability world of the sort of top-notch plaintiffs' counsel in certain of these locations, which creates almost a self-fulfilling prophecy where once a series of lawsuits are filed, more plaintiffs' attorneys move to that jurisdiction, meaning more lawsuits get filed in that jurisdiction. So the next piece of this is favorable law, or for all of our purposes, unfavorable law. That, as we all know, the United States has 51 different sets of laws, and the laws can be radically different. Let me just give a quick example that I think makes a big difference to all of us as we're defending cases. I assume everyone on the call is familiar with the concept of prejudgment interest, basically how much interest has to be paid on any judgment award if that award is given. And in a defense-friendly jurisdiction, for example, Utah, the current rate is about 3% for prejudgment interest. Now, in a plaintiff-friendly jurisdiction, like Massachusetts, the current rate is 12%. I know we all wish that we could get that sort of return on any of our investments. Frankly, the best place for any investment is to be a plaintiff suing a company in the state of Massachusetts. So that's an example of why the laws in Massachusetts make it a little more likely for a Massachusetts location to become one of these bad jurisdictions than a Utah location. Let me give another quick example of that, and that's comparative fault. This is what percentage a defendant has to pay of the fault that the jury assesses to it. So if you are back in Utah, it's pure comparative fault. A defendant only has to pay its percentage of liability. Now, to go back to Massachusetts, and bear in mind, I'm not a Massachusetts lawyer, so I'll do my best to explain this right, but if I get it slightly off, my apologies. So basically, in Massachusetts, it's almost pure joint and several liability, where a defendant has to pay up to a share of the proportion of the total number of defendants. So hypothetically speaking, in a two-defendant case, if one defendant is found 1% liable, it can be compelled to contribute 50% of the total judgment award. So all of a sudden, if your company is getting sued in Massachusetts, you're facing 12% prejudgment interest and the possibility of the jury saying you're 1% at fault, yet being responsible for so much more than 1% of the total award. The final piece that we have to consider is the judges in locations, and that there are specific jurisdictions throughout the nation. Some states' judges are elected, some states' judges are appointed, but there are states, especially where judges are elected, where in certain locations the judges either get most of their campaign contributions from the plaintiff's bar, or quite commonly the judges are former plaintiff attorneys themselves, and most judges in a jurisdiction fall into that bucket. And that helps create as well these bad jurisdictions for corporate defendants. So with those factors in mind, just everyone thinking about what's your jury pool, how many people are part of the plaintiff's bar in that jurisdiction, what the law says, and what the judges are like, that creates these bad jurisdictions. So at this point, I was going to hand it over to Mark to talk just briefly about the location of these jurisdictions.
Thanks, Jordan. Good afternoon, everyone. So as Jordan and I were developing this presentation, we were very cognizant that we're taking a little bit of a risk if we label certain venues as bad venues, and particularly if we're perceived as criticizing the judges or juries in those venues, which is really not our intention anyway, as I'll talk about more in a moment. But we even thought maybe it would be better just to talk generally about bad jurisdictions and how to get out of them. But then we thought, what fun would that be? So we are going to give you a list of what we feel are some of the worst venues for defendants, and particularly defendants in pharmaceutical and medical device cases. But before we look at our list, I want to talk just briefly about what is probably the best known list of this type. The American Tort Reform Association publishes every year a list of what they call judicial hellholes. So obviously a little more provocative title than we've chosen for our presentation today. And I really want to comment on that. The moniker they use, judicial hellhole, suggests that maybe there's something wrong with the juries or the judges here. They're all ignorant or unfair or something like that. But this is all relative, right? We're talking about plaintiff-friendly jurisdictions. And as I mentioned to Jordan the other day in discussing this, I live in DuPage County, Illinois. Now, I'm talking to you from Cook County, one of the notorious plaintiff-friendly jurisdictions today, but I live out west of Chicago in a county that's very conservative, that has conservative jurors that, do crazy things like enter awards for defendants and do crazy, and we have summary judgment being granted by the nutty judges out there, those kinds of things. That county, DuPage, is probably a plaintiff's judicial hellhole. So it's all relative, and the point is not to criticize anyone here, but to talk about the realities of pro-plaintiff jurisdictions. So taking a look first at the list, most recent list from ATRA, I just want to explain why this list is a little different than our list. We did try to focus more on litigation that this audience is more concerned with, so pharmaceutical, medical device litigation. ATRA is a more general list. But looking at it, there's obviously a lot of overlap here too. So they talk about California, and we are going to talk about that. Jordan's going to talk about a couple of counties in California. We think to talk about California, the entire state, and all types of litigation as being one of these terrible venues is a little too broad. New York City asbestos litigation, many of my partners practice in that area, and they could, I'm sure, talk all day about that. It's just not that relevant for our purposes today. Florida, we know, is a challenging defense venue, but again, I think the reason ATRA had this on the list, in part, was because of the proliferation of medical malpractice litigation there and some recent developments, rulings by the Supreme Court there. One of the things the Supreme Court did was strike down damages caps in medical malpractice cases, but frankly, if you're defending the manufacturer of pharmaceuticals or medical devices, it might be pulled into what is also a medical malpractice case. That could actually be something good for the manufacturer, because it means that the doctors remain a deep pocket defendant and doesn't necessarily require bringing in a manufacturer, as we see in other states with laws, caps and things, such as in Texas. Missouri, we're going to talk a little bit about that in the context of the St. Louis Circuit Court. Madison County, Louisiana, those are both on our list, and we'll talk about those. Hidalgo County, Texas, that is a county that is kind of infamous for first-party insurance claims, bad faith litigation against property damage insurers and that sort of thing, so not as relevant for us. But we do have East Texas generally on our list, and we'll talk about that. Newport News, Virginia, I think that is primarily known as, again, as an asbestos litigation hotbed. Jordan and I don't feel Virginia is necessarily one of the worst jurisdictions, but obviously asbestos litigation and the juries in particular in Newport News were viewed as ATRA as being problematic. And then the District Court for the Eastern District of Texas, which interesting that ATRA would have a federal court on their list. That is a notorious dumping ground for patent infringement suits by what they call patent trolls. So again, not so relevant for our purposes. So let's move on to the Jordan and Mark list of plaintiff-friendly jurisdictions. The first we have, which I found odd, it was not on the 9 worst jurisdictions listed by ATRA, Philadelphia. I know Jordan and I agree that from our own practice and experience there, and my firm has an office there too, and many lawyers practicing there every day, I feel it fits really all of the categories that Jordan described. You have clearly pro-plaintiff juries, both liability and on damages, are very liberal in their awards. You have a very aggressive and I think competent plaintiffs bar there, attorneys that will push the litigation. The judges are extremely pro-plaintiff because they're a product of a political system, and as Jordan mentioned before, and as we'll talk about for a lot of these jurisdictions, the problem you have that a lot of them have been plaintiffs' attorneys in their own previous life. They're very friendly with the bar. They get campaign contributions. All of this is legal, but it's a problem. And I think that there really is no factor that you could say in Philadelphia does not apply. I think Jordan actually is going to talk now a little bit about Los Angeles and Alameda counties.
Yeah, and so as Mark said a minute ago, there are some great places in California to be a defendant. Better judges, better jury pools from the defense standpoint, but there are certainly some places that are not pleasant to be a defendant. And the two on our list that we put were Los Angeles County and Alameda County, though one could certainly have arguments for other counties, such as the city and county of San Francisco, possibly Santa Clara County, or some other locations. The first thing is that California law is challenging for those on the phone who are from a drug background or work for drug companies. The Conti decision out of California, which basically holds that a brand name drug manufacturer can be liable to a plaintiff who has never ingested their product and has only ingested a generic version. That's the Conti case. Virtually every other state rejects that and says, no, if you're going to be sued in a product liability lawsuit, the plaintiff has to have actually used or ingested the product at issue. Not true in California. So we start with the problem of California law. Then we add on the jury pools that you get in Los Angeles County and Alameda County. For those who are not that familiar with Alameda County, that is where you have both the cities of Berkeley and Oakland. And then beyond the jury pool, you also have issues of cases taking a while, which, while normally on the defense side, there might be a feeling that you don't want to rush through cases too quickly. When the case is lingering and stressing out the company for year after year after year, that can be a huge issue, and a true lack of predictability as you come into trials. So Los Angeles and Alameda County were two that we thought should go on the list. And just as a side note, for anyone on the call who the drug and device companies haven't been seeing this as much as a lot of other manufacturers, but Los Angeles County is currently the hotbed for sort of the consumer fraud lawsuits. I was just reading in the legal press the other day that Budweiser is being sued for false advertising because their Abbey Ale is not made in an Abbey. I forget if that suit was going on in Los Angeles County or if it was going on somewhere else, but that's the sort of typical lawsuit that Los Angeles is just seeing many, many, many types of cases. So with that, I thought I would hand it back to Mark, who lives in Illinois and can talk about Madison and Cook County.
Thanks, Jordan, and hopefully you're not holding that against me. I am in the one state that has the distinction of having the two counties here other than California. And I don't practice that much down in Madison County, which, for anyone who doesn't know, is at the southern end of the state and really borders the St. Louis area and part of a whole metropolitan area there. It has been near or at the top of these types of lists for a very long time. And far and away, I think the biggest problem there is the judiciary. There is a political system there that allowing campaign contributions to be made by the wealthy plaintiffs' attorneys to the very people who are going to be ruling on their cases as well. And litigation is an industry in Madison County where some of the wealthiest people in that county who can finance the campaigns of the judges and who can put people up for election and get them slotted and get them onto the bench are the plaintiffs' attorneys who've been successful in particularly in asbestos litigation, but in many other types of product liability and other litigation as well. Unfortunately, that venue is made much worse by the fact that there is a very plaintiff-friendly appellate court, something we'll talk more about later. So the 5th District Illinois Court is not likely to overturn any large plaintiff verdicts or to help on any of the rulings that defendants are not able to get to go their way in the trial court. There's also a relatively fast docket there where cases can get to trial in less than 2 years, and that's viewed as a plus for filing cases, drawing cases to Madison County that maybe have no business being filed there. Illinois law is generally pretty favorable for plaintiffs as well. One thing about Madison County that I'm going to talk about a little bit later is that the jury composition there has been changing in recent years, and that may be something that's a little bit surprising for most people. It was a very blue-collar area, mostly white area, but a lot of people working at industrial facilities in that area that are now mostly gone, and it's become a little bit more of a suburban venue, different demographics. So on that factor, it may not be as bad as a lot of people think. Cook County, I debated whether to even suggest that Cook County maybe shouldn't be on our list as one of the worst venues for defendants, but I think it still merits inclusion on the list, primarily because juries here are so liberal on damages. But I think it needs to be understood that that does not necessarily mean you cannot win a case on liability. Many defense verdicts are rendered here in Cook County. Again, the appellate courts and all the way up to the Illinois Supreme Court are generally not very helpful to defendants. There have been some recent, particularly bad Supreme Court cases I won't go into right now, but it's viewed as a hostile environment in general to defendants. And I think one of the things I have to say, I hate to tip my hat at all to our opponents, but the plaintiffs' bar in Chicago is extremely competent. A lot of very good, aggressive lawyers, not necessarily unscrupulous by any means, but they are just good at what they do. And so litigation here has also been an industry for many years. With that, I'm going to ask Jordan to make a couple comments on New Jersey.
So, as you may recall, New Jersey is not on the ATRA list, and but for our purposes, it's important to list New Jersey, with the probable sole exception of the PCCP, the Philadelphia Court of Common Pleas. The most number of drug cases end up getting filed in New Jersey, and there's a variety of reasons for that, and obviously we can't touch on all of them on this call, but a few quick thoughts on this. So New Jersey, first of all, the expert standards are pretty relaxed. It's pretty easy to get junk science into the courtroom from the defense viewpoint, but there are also other legal issues. And in fact, for those on the pharmaceutical side, just in the last week and a half, the New Jersey Supreme Court handed down a discouraging decision for drug companies, and this was in the Youre Reglan litigation. By the way, this is roughly 1,000 Reglan cases have been filed in the Superior Court of Atlantic County, New Jersey, which just goes to show you right there how this is a plaintiff hotbed of drug litigation. But in the Youre Reglan litigation that came down a week and a half ago, the New Jersey Supreme Court rejected generic drug preemption in the failure to update realm. This is where the allegation is made by the plaintiff's attorneys that the generic drug company did not timely update its label to match the brand name drug label. So New Jersey is simply not a great place to be if you are a drug or device company. And I was going to hand it back over to Mark to talk about Louisiana.
Yeah, I'll try to move through some of these others a little more quickly so we can get on to more of the meat of the presentation here. But Louisiana, another venue where juries are viewed as obviously plaintiff sympathetic, anti-corporate, very liberal on damages. They have loose venue rules, so you have a lot of cases being, in New Orleans that maybe shouldn't be there, New Orleans being probably the worst venue in the state. Their Supreme Court is particularly plaintiff-friendly, and they have no intermediate appellate courts in Louisiana. So, again, appellate review, trying to win the case that you lost in the trial venue is very difficult. Interestingly, though, Louisiana, on the law, though that some of their laws is pro-plaintiff, but they have some interesting pro-defense, potentially, statutes as well, including that they have no punitive damages except for very specific statutory, created rights, which mostly involve sex crimes and things like that, so they're not going to come into play in a product liability case. So you don't have to worry about punitives. They have a one-year statute of limitations, and I personally have had at least one case down there where the judge in the Supreme Court did affirm a dismissal for violation of the one-year statute of limitations, despite all the exceptions that the plaintiffs were trying to claim. So it's not all bad on the law in Louisiana. St. Louis Circuit Court, again, right next door to Madison County, and very similar in terms of a lot of the problems with the judges, juries, a lot of large punitive awards in Missouri in recent years. One of the unique problems in Missouri is they have really no kind of Daubert, expert testimony controls. Most states either follow Daubert or follow their own kind of rules that at least have some kind of gatekeeping function. And Missouri is more of a throwback to allowing all of this junk science to be brought in by plaintiffs, another problem for defendants. Next, we had East Texas on our list here. Now, this is an area, again, where you have a very aggressive plaintiff's bar, kind of infamous plaintiff's bar in the whole state going back for many years. And I think East Texas is still problematic, mostly because, again, a political process that has led to the trial judges in this region being extremely pro-plaintiff, even to the point of sometimes ignoring some of the provisions in the recent tort reform there. I'm talking about an area really in Texas along the Louisiana state line, so it's not that different than a lot of the Louisiana venues as well. The good news is in Texas things have been changing, and again I'll talk about that a little more in a moment. But they did have tort reform over the past several years. And their appellate courts can be very defense-friendly, including their Supreme Court, which, Texas has obviously, become a red state. So in terms of the law and the appellate venues, it's actually a much more favorable jurisdiction than most of the jurisdictions on our list. West Virginia, another jurisdiction kind of classically known for liberal juries who are anti-corporate. Their Supreme Court is also, rather notorious from a defense perspective. They recently handed down a decision in a case last year, a Valley Pharmaceutical case, in which they held that plaintiffs who had been criminally seeking drugs by falsifying prescriptions and things like that to get more painkillers at their pharmacy could sue the pharmacies that filled the prescriptions that they were forging, even when they had been convicted for criminal behavior in that regard. So it's very plaintiff-friendly jurisdiction on all levels. I think our last jurisdiction then is the Boston area, which Jordan is going to talk about.
And the reason why I thought that this one should be on the list is, as we talked about a few minutes ago, there's joint and several liability in Massachusetts. The prejudgment interest is extraordinarily high, and when you couple those facts with the fact that Boston juries aren't afraid to award very large numbers, that really creates it as one of the problem jurisdictions for us to work with. So with that, Mark was going to talk for a few minutes about the sort of common misunderstandings about these jurisdictions.
Right. Thanks, Jordan. So having given you these jurisdictions, of course, as lawyers, the first thing we're going to do now is give you a bunch of caveats and qualifications. But really the point is that whenever we place labels on anything, including a jurisdiction as good or bad, there are a lot of dangers with that. And I think there are a lot of misunderstandings. And the biggest one being that just because something is a bad jurisdiction doesn't mean you know all that you need to know about it, including what you need to know to defend a case there if you're stuck there defending it. There are different factors like Jordan talked about at the beginning, and some jurisdictions have some of the bad factors present but also have some good factors. So I just talked about Texas, a great example. Their Supreme Court a couple of years back had reversed 23 large plaintiff verdicts in a row that they had reviewed. So for defendants that are kind of willing to stick it out there and challenge things on the law, pursue the larger cases through the appellate courts when needed, or at least can give that message to the plaintiff's bar early on. I think things have really turned around in Texas, although, again, certain jurisdictions out east there are still not very desirable for defendants. State law, like I said, in Louisiana, it may be pro-plaintiff in some respects, pro-defense in others. And there are actually some jurisdictions, too, where you may have a problematic judiciary, you may have bad law, but you may have defense-friendly jurors. So we talked about California earlier and how calling California as a state a judicial hellhole, as ATRA did, may be a bit of an overgeneralization. I mean, if you are in Orange County, where I've litigated quite a bit in recent years, if you can get a good jury pool, you actually can get good judges there too. It can be a defense-friendly jurisdiction. It may depend more on what type of case you're talking about. Is it some kind of consumer fraud case or ADA case or something where there's a lot of pro-plaintiff law in California? Or, if it's a product liability case, you may be in good shape there. I think there are a lot of overgeneralizations. For example, California, like we just talked about, also Cook County. Yeah, even in talking about juries themselves, my feeling in Cook County, as I think I mentioned before, is that Cook County jurors, which are now becoming a little more diverse in terms of having suburban jurors and so on also, but they tend to be extremely liberal on damages, maybe 2, 3, 5 times the awards we would have in the collar counties in Chicago, but not necessarily any more pro-plaintiff on liability, particularly in product liability, medical malpractice cases. Some of the stereotypes regarding judiciary in a particular venue, I think, can be really misleading as well, because the only judge that matters is the one that you have. So in any jurisdiction, for example, Cook County, just because most of the judges have previously been plaintiff's attorneys, may have a pro-plaintiff bias, you still could get a judge assigned who's a fair judge, a very competent judge, a strong judge, and you need to look at it on a case-by-case basis. I think that a lot of these jurisdictions have reputations that actually can be outdated. So I mentioned Madison County earlier. I think the juries are changing there. In 2012, obviously Barack Obama was reelected very easily throughout the country, and I'm sure you probably know that Illinois is a blue state and voted for President Obama. But surprisingly enough, Madison County voted for Mitt Romney. It is not necessarily the jury pool that people think it is. So the judiciary is really the biggest problem there. But if you have a case you're trying to win through jury appeal, maybe it's not the complete hopeless jurisdiction that you might think it would be. And then again, Texas in general, I think, in terms of outdated reputations, I think a lot of people still view it as a hotbed of litigation, but with tort reform and with the way the Supreme Court has handed down decisions in recent years, Texas has become a much more conservative jurisdiction, and actually litigation there, including product liability litigation, has really been declining in recent years. So those are our comments about the bad jurisdictions and where they are. And I think now Jordan is going to talk to us about how we can try to stay out of or get out of some of these jurisdictions.
So as I said before, the spoiler alert is that there aren't many ways of staying out of these jurisdictions, but there are a number of ways of trying to either stay out or get out quickly. And so in order to understand these, it's important to have an understanding of both the personal jurisdiction and of how removal to federal court works. And personal jurisdiction. Okay, so this is a topic that bores attorneys and bewilders non-attorneys. So let me try to do it briefly and simply for the non-attorneys in the audience. I assume that you know the basics of it, but just to start at the very beginning, personal jurisdiction is whether the state court has the power to hear the case over you as the defendant. So if you are a medical device manufacturer, you are based in Ohio, your research and development facilities are in Ohio, your plants are in Ohio, and you only sell around the East Coast, there is a strong argument that a court in California or Oregon or Utah does not have personal jurisdiction over your company because you simply do not operate or directly sell into California, Oregon, or Utah. So that's the very basics of what is personal jurisdiction. And personal jurisdiction is divided into two pieces. The first one is general jurisdiction, which is probably the easier term to understand is the all-purpose jurisdiction. So let's take sort of a common example for a medical device company. Let's say the medical device company is headquartered, the principal place of business is in Pennsylvania, and the device company is incorporated in the state of Delaware. That's very common. Now, if there's a Nebraska plaintiff who uses the medical device based upon a Nebraska doctor's recommendation, and the product at issue was made in a plant in Kentucky where it was also designed, the Nebraska plaintiff can still sue in either Pennsylvania or Delaware. So there doesn't have to be any connection between the lawsuit, that is where the plaintiff claims to be injured or where the plaintiff took the drug, used the device. Rather, it's simply a question of if you are at home in a jurisdiction as a company. Under this example, Pennsylvania or Delaware, you can be sued anywhere in that jurisdiction for anything. And I think Mark would agree with me that our bet would be that your company would be sued in the Philadelphia Court of Common Pleas under that hypothetical. Specific jurisdiction is a little different. And specific jurisdiction, using that same example again, this is case-linked jurisdiction. This is something happened in the actual case that linked the defendant to that jurisdiction. So remember, general jurisdiction, basically, with some caveats that we could talk about down the road, but general jurisdiction, basically, it's only where's your principal place of business and where you incorporated. But specific jurisdiction looks into those case-specific facts. So under my Nebraska example, if the plaintiff uses the medical device in Nebraska, it was sold to them in Nebraska, the company makes a product in Ohio, developed it, and did all that in Ohio, then there are arguments the plaintiff has to sue in either Nebraska or Ohio, as well as Pennsylvania and Delaware. So that's specific jurisdiction. That's case-linked jurisdiction. The technical question for this is whether the defendant has purposely directed its activities at the forum state, and then whether the plaintiff's claim arise out of or are related to those forum-directed activities. And by having that state hear the case, it's not offending traditional notions of fair play and substantial justice. Those are the elements, so to speak, that courts find for jurisdiction. And then the next thing that's important to understand, and I'll get into a minute why this matters from a proactive standpoint, but is the issue of removal. And for those in the audience who aren't immediately familiar with this, basically removal is when a defendant takes a case from state court and removes it to federal court. And for every single bad jurisdiction for defendants that Mark and I listed on our list, they were all state courts. So for all of those, you'd almost always rather be in federal court. There are a variety of reasons for that. You have judges that are appointed by the president. You have a larger jury pool. It's not just one county, but it's a bigger area. There are certain laws that are better if you're in federal court, such as Rule 702, which is the evidentiary standard for getting in expert evidence. So a variety of reasons why you'd rather be in federal court than basically any of the bad jurisdictions that we named. Now, this is not, of course, to say that all the time a defendant wants to be in federal court. There are plenty of counties, both in Mark's home state of Illinois and my home state of Colorado, where, frankly, you'd rather stay in state court than go up to federal court for a variety of reasons. But removal is important, and removal can only occur if all the defendants are out of the state where the lawsuit is happening. And when I say the defendants are out of the state, what I mean by that is that their principal place of business and their headquarters are outside of that state. The principal place of business, that's their headquarters, and they are incorporated out of that state. So, because most companies, not all, but most companies are incorporated in Delaware, it's very hard to remove a case from Delaware because the company is incorporated there. It's a home jurisdiction for the company. And then the controversy is over $75,000, which is met in virtually every case that we deal with in the drug and device world. So just a quick note on this. How do plaintiffs avoid the defendant removing? Well, two of the quickest and easiest ways of avoiding removal are naming a doctor from in-state or naming a sales rep from in-state, because all of a sudden there is a defendant who is located in the state in which you're being sued. So that's just a brief overview of jurisdiction and a brief overview of removal. And why does all this matter from a proactive standpoint? Well, look, if you're at a big drug or device company, you're not going to make the decision of where your business is located based upon the risk of being sued for product liability lawsuits. But for small companies, this actually can play in and should be part of the calculation as a company considers where is it located and also where is it incorporated. And just to give an example of a company that I've worked with that is based in Colorado, which is generally a pretty defense-friendly jurisdiction. That's where its headquarters are, that's where its principal place of business is, but it is incorporated in Illinois. So it can be sued for any case arising anywhere in the country, in Cook County or Madison County or any other bad county in Illinois. So as you're thinking about where is your company located, that plays in. And if you think about the example that I just gave of the company that is incorporated in Illinois, that company cannot remove any of those cases to federal court either. So they're subject to the jurisdiction of Illinois courts no matter what, and they can't remove the case to federal court no matter what. So one thing for the smaller device companies and other manufacturers to think about is, should you be incorporated? Where are you incorporated? Where are you located? Where are your primary facilities? A similar issue, and I don't want to get too far into the weeds, is whether you're a corporation or an LLC. Because for the purposes of removal that we're just talking about, an LLC is measured by where its members are located, as opposed to where just a corporation is incorporated. So there are a number of those issues to consider, which in turn gets us into the question of, well, how do you get out of this plaintiff-friendly jurisdiction if your company is sued there? Well, the first thing that you should look at is, can you challenge the jurisdiction? Are you that company based on the East Coast with your operations on the East Coast and you're being sued in California? And I've had great success with this from many of the very bad jurisdictions that we've listed before, frankly, where we didn't even get to the point of getting a court order. We would go to the plaintiff, we would file our motion to dismiss based upon a lack of personal jurisdiction, and frankly, instead of fighting this, and instead of getting a bad appellate rule on the issue, the plaintiffs would simply let our clients out. So challenging jurisdiction is very helpful. The next thing that you can think about is challenging venue. And for the for the non-attorneys who are in the audience, venue is, in simple terms, which county in the state you're being sued in. And so there are oftentimes arguments that one can make to say, oh, this case shouldn't be in X county, but it should be in Y county. Let's move the venue of the case. So that's the second thing to look at. The third thing is what's called a forum nonconvenience motion. This is different than a jurisdictional or a venue challenge in most states. Obviously, 51 states, 51 different sets of rules. But forum nonconvenience basically is the concept that there are that the court, while it does have personal jurisdiction over the defendant, believes that the action is more appropriate to be tried in a different state, and therefore will dismiss the case from that state. And then finally, there's the removal issue that we talked about a few minutes ago. If you are sued in state court as a defendant in a bad jurisdiction, the first thing that you look to is, can you remove from federal court? And there are two time frames that play in here. The first one is 30 days after you're served with a complaint is your first window to remove. But let's say that your device company and the prescribing physician are both sued in the same case. Well, there's not diversity of jurisdiction, which means that you can't remove the case to federal court because the doctor presumably is in the state that the bad jurisdiction is that you're being sued in. Well, that doesn't mean you won't be able to remove down the road, because there's another rule, a one-year rule, that says that if the case becomes diverse within a year, you can remove. So, for example, if the doctor settles out or gets dismissed out within that first year after the lawsuit is filed, you can then remove the case to federal court. Now, one thing to bear in mind as we're talking about attempting to get out of these plaintiff-friendly jurisdictions is the problem is these are plaintiff-friendly jurisdictions. So the assumption oftentimes is that the courts do not want to get rid of these cases. And in fact, there have been two decisions issued just in the last week on this issue. The first one, which all of us may be hearing a lot about over the next few years, is the Bristol-Myers Squibb case from the California Supreme Court that literally came out on Monday, which found that the San Francisco state court, had personal jurisdiction over Bristol-Myers Squibb, even though Bristol-Myers Squibb is not located in California. It was found under specific jurisdiction. And if anyone's curious to read more about that case or the Illinois case that came out about a week ago, finding the same thing with regards to GlaxoSmithKline, there is a blog that I just put up on the Medmarc blog website that talks about those cases, provides sites, and can give you information about how that works. So in other words, when you're in one of these plaintiff-friendly jurisdictions, the courts are going to do oftentimes what they can to keep you from getting out of their court. So with that stated, I was going to move over to Mark for what to do if you're stuck.
Thanks, Jordan. I'll try to cover this quickly so we can have time for questions. You've tried everything that Jordan has described. You can't get out of the jurisdiction. You could just send the plaintiff's attorney a blank check and say, here, fill in a number and send me a signed release and we'll be done. But that's probably not your best option, so you need to defend the case there. First thing that you probably need to do is get the right local counsel. And that can be a more complex decision than it may sound like. Obviously, you want someone who has credibility there and who is familiar with not only the state law but the local procedural law, the specific judge you're assigned to. Hopefully he has experience or she has experience with that judge. Someone who can help to evaluate cases for you and tell you what to expect from the jury, that type of thing. Now, in medical device and pharmaceutical cases, often you have involvement of a national or regional counsel as well. You may have mass tort or pattern litigation that requires that, or you may have just a very knowledgeable defense firm that is defending a certain product all around the country. That can definitely make sense. But I think you have to be very cognizant in these difficult plaintiff-friendly jurisdictions of what the role should be of both local and national. You may need to curtail the role of a national or regional counsel in certain locales. If you're in East Texas or you're in rural Louisiana, you may not want your Boston national counsel coming in and giving a closing with their Harvard accent. At the same time, I think you may need to look to your national or regional counsel to help develop a strategy that could rock the boat in that local jurisdiction, because some local attorneys there may feel that they don't want to go up against some of these judges or even some of the local plaintiffs' attorneys who they may golf with on the weekend. They may not want to take them on in the same aggressive way that a national counsel would be willing to do. And for example, when we think about Texas, if you're going to try to go all the way through and say, hey, if this trial judge denies my meritorious summary judgment motion, I'm going to appeal it, and I'm going to appeal it all the way up, you may find that the local attorney in some East Texas county is not as willing to do that. You may need that local on your team for when you're in court, but you may need national and regional to step up and take a larger role in the defense as well. I think one of the biggest things that you can do is really just evaluate your case appropriately. I mean, you can only do what you can do based on what you have in that venue, the facts of your case, and the jury and the judge that you have. You can evaluate the case, though, using the expertise of local, as I just mentioned. There are resources. If you're in Cook County, you can certainly look at the Cook County Jury Verdict Reporter and see what kinds of crazy awards have been given by juries in similar cases. And I think you should consider, in the very big and dangerous cases or in pattern litigation, you should consider a mock trial with mock jurors from that jurisdiction. So if you have a case and you're stuck in the Philadelphia Court of Common Pleas, you may want to do a mock out there, bring in Philadelphia mock jurors, not just to see what they do, but if you've been a part of these exercises, as I imagine most of you have, you know that you can actually sit and watch deliberations and see what things are important to these local jurors. You know, what arguments resonate or don't resonate, what witnesses are going to do well in front of this maybe pro-plaintiff panel, and which ones will not. One of the other things you need to do is preserve your appellate options. That's pretty self-explanatory. No one wants to take a defeatist attitude, but the reality is that if you're in a difficult venue where the jury is anti-corporate and the trial judges are bad, but the appellate judge or the law in the state may still be favorable for the defense, you may need to have an appellate lawyer involved early and really be thinking about that strategy from much earlier in the case than when that verdict comes down. And then finally, I wanted to make a couple of comments about adapting strategy in mass tort defense, because in pharmaceutical and medical device litigation, obviously we many times do have pattern litigation around the country, or mass tort, or even class actions, and there may be an MDL where most of the litigation is concentrated, or a certain dumping ground in a particular state, but some cases cannot be removed to federal court, as Jordan mentioned, and you'll always have cases all around the country. So you have to have a national strategy that says we are not going to allow some of these horrible pro-plaintiff jurisdictions to be the precedent setters for our litigation. You want to avoid having your first trials in a jurisdiction where the juries are the most liberal in the country. You may need to consider confidentially settling a case in Philadelphia and pushing an Indiana case forward to trial to be your first trial when you have a mass tort. You may need to think about which judges you want ruling on, or being the first to rule on those pivotal legal issues in your case. You may not want a judge in Madison County to issue a ruling which is then affirmed by the 5th District Appellate Court there, and maybe even by the Illinois Supreme Court, and then would be cited in all of your other cases around the country later. So those are just a few thoughts on how to handle some of these difficult venues when you're stuck there. And Jordan, unless you have some other issues, comments on that, I think we'll be turning it back over to our hosts for the question and answer session.
So yes, I do think we're ready for questions.
Great. It looks like we've got a couple that came in. So we'll start the Q&A session now. If you have a question, please feel free to submit it using the Q&A panel located at the bottom right of your screen. After typing your questions in the space at the bottom, hit the send button. Please be sure to direct your questions to all panelists in the Ask menu. Your questions will not be seen by other members of the audience. So let's start out. It looks like this one's for you, Mark, I would think. What jurisdictions not on your list now can you foresee becoming major problem venues in the future?
Well, for my personal experience, in the last 5 years or so, I would say the Pacific Northwest is a problematic area for defendants. In particular, Oregon is a very unusual jurisdiction. You know, you have the demographics may not be similar to some of these inner city venues where people consider juries to be difficult, but it's a very liberal, anti-corporate environment. Pro Bernie Sanders supporters, and Oregon in particular is bad because they have really what's known as a trial by ambush system, because they don't allow interrogatories of any kind. They don't allow any expert discovery. So the plaintiff's attorneys, all they have to do is sign something that says, yes, I've got an expert, and that basically will get them past summary judgment and to a trial where for the first time you will hear what opinions that expert has. So I've had some experience there, and I've also found even in federal court there it's problematic because the Ninth Circuit out there is extremely liberal. So I think that is an up-and-coming problem jurisdiction.
Thanks, Mark. Jordan, do you expect the Supreme Court to weigh in on specific jurisdiction at any time soon? And if so, will that have some impact on these bad jurisdictions?
Yeah, that's a great question. So we all know back in 2014, the U.S. Supreme Court in the Daimler decision, what it did was it basically really pared back the places that a company could be sued at under general jurisdiction. That was the case that said, look, basically, with a few exceptions, it has to be principal place of business or the domicile of the corporation. Those are the only states that you can get sued at, which leaves the window open under specific jurisdiction. And that is where all these decisions are now going, is under specific jurisdiction. Is there a way to get the corporate drug or device manufacturer into the state? And the new case that just came out on Monday, Bristol-Myers Squibb, will actually be an interesting one to see whether, first, if the cert is sought, if the Supreme Court grants cert on it, and if the Supreme Court does grant cert on it, will the Supreme Court reverse that decision? This is the California Supreme Court one. I know that's a lot of ifs, but if all three of those ifs happen, and at least on the first one, it's worth noting that the California Supreme Court said that they were disagreeing with the First Circuit on this, and it is a constitutional law question as we're dealing with jurisdiction. So there is some possibility that the U.S. Supreme Court will weigh in at some point soon on specific jurisdiction, and we will all be watching it very closely because it will have a tremendous impact on drug and device companies and all sorts of other manufacturers throughout the nation.
Thanks, Jordan. Looks like we've got time for one more here. Jordan, I believe this is aimed at you, and it kind of asks you to go back to a part earlier in your presentation. It says, under the general jurisdiction hypothetical, what if the plaintiff sued the Pennsylvania defendant in Madison County, assuming the defendant's income, 4% of the defendant's income comes from the state of Illinois? Okay,
so under that hypothetical general jurisdiction, there should be no general jurisdiction. However, the second part of that is, will there be specific jurisdiction? And let me just say, as a defense lawyer, my answer would be absolutely not, and of course not. Now, the real question is, how many judges can I get to agree with me on that point? When you have this situation where there's a small percentage of sales, but not a big one, and these are the issues that the California Supreme Court was just grappling with at the Illinois Court of Appeals for the first division was addressed 2 weeks ago. This is sort of the hot topic right now in specific jurisdiction. So while my defense answer is no, you can't get jurisdiction in that circumstances, I think the courts are going both ways on that issue.
Great, thank you. It looks like we're right at the hour, so we'll finish up there. Thank you so much, Mark and Jordan. I know we really appreciate your insight and your experience on these. You have a unique perspective, and we appreciate you delivering it to us.